Okay, we will start today's class. Today we are going to see one of the important area in CLD because every time when you analyze the previous year questions, there'll be one question from this topic, which is your intellectual property rights. So this intellectual property rights have various acts, and one important act is your Copyright Act. Very important. So if you're going to cover all these acts by your own, it will take a lot of time. That's why we have our classes. So once you do the classes and then take your handmade notes from the slides that we are giving and cover it up with your answer writing practice, you are ready for your UPSC Law Optional Examination. So welcome to Lawxpertsmv India. Today we will start with Copyright Act. So first of all, we have to know why do we need copyright? Because all these substantive facts will help you in writing your introduction and conclusion, which is the hardest part for any UPSC law optional aspirant. Because everyone calls me and asks, ma'am, how to write an introduction, how to write a conclusion. If you know all these facts, then you can give a very good introduction, standing apart from your competitor. Okay, so first, why do we need copyright? It is because of the change of the mindset, actually. Okay. So ancient times, if you see, first we will start with the improvement factor. That is, in ancient time, if anybody writes a book, how do they copy the book? The other person will sit and write the manuscript. Like that, they will make the copies. And as the time went, then we got the printing process. That was the new era which made copying very easy. So earlier, when anybody creates a poetry or something, it's not hard. Like copying is really hard. They cannot do multiple copies and spread it to any other people. But after this printing era, copying became so common. And nowadays in the digital era, copying is something very easy that we can do it in a snap. Okay, so that was the thing. Anciently, there is no mechanism for copying. Per se, copying was hard. None of them did it. So no need of protection. But today, copying is very easy. We need a law to protect copying. That is first point. Next, change in the mindset. At ancient point of time, doing any artwork was only for fame. See, I have done this particular artwork. So I am the author of the work, and it was only for fame. But today, there are ways to create money enriched from the work you do. Because you have put all your hard work, your intellect over there. If you're able to commercialize it, yes, you can do that in today's world. So it is not an artwork, it is also a way of minting money. So it needs a control. Okay, if you are very keen on laws, wherever there is way to mint money, there always be a law to control it. Soon, I hope we will get a law to control cryptocurrency as well. As now, when we say cryptocurrencies are not regulated in India, but if you are going to change the cryptocurrency into Indian rupees, you have to pay 30% tax. Okay, so you have to be very clear when we talk about copyright law. Why do we need a copyright law? Is because the time changed. Copying became very easy. So we can actually manipulate anything. That's why we need protection. One point. Next point is that author's mindset is changed now. It is not only for the fame, but also you can commercialize it. So when money comes into picture, there needs control. Okay, that's why we have copyright laws. Now, why do we actually need copyright? We have a small important area which we need to take care of. That is encouragement to the authors. See, if you all think to clear UPSC, right? Why do you? Because you have the aspiration, all those things. And in your heart, you will have this point. That is validation. Your parents will be happy if you clear. Your relatives will validate you, will look upon you when you clear. Everybody will have that, right? So you need that validation. Everybody needs that validation. That's what we are giving it here. And author, when we validate that person, he is going to be the author. He is the creator of that work. So I am protecting his authorship and nobody can copy his work. Now what happens? He gets an authorization. So because of this authorization, we encourage the author to do even more well. Okay, so that is the object. So what is the object? The object is to protect from unlawful reproduction or exploitation of an author's work is the total idea of copyright. So when you do that, the author will get the validation. So he will get an encouragement to do a lot of new things. Simply saying hard work is given a proper recognition. When that is done, then the hard work will be boosted. Okay, that is the idea. So these 3 points will be very useful for your introduction. First, in ancient time, no printing means, so copying was not so famous. In digital era, copying very famous, so we need copyright. Next, and copyright is not only a fame, it can be commercialized, so we need copyright protection. And there is one author who's putting all the hard work. We must recognize the person and stop others from infringing his work, so we need copyright. Okay, all these things you have to say. Next, what is the nature of this copyright? It is a negative right because it prevents others from doing something. You don't do this, you don't do this. That's what is copyright. See, he is the author, so you don't copy it. He is the author, you don't publish it. He is the author, you don't reproduce it. So, we are saying don't do it. When that is the thing, it is called as a negative right. So you are preventing others from copying and reproducing. That's why copyright is a negative right. Okay, so these are all basics. Now coming to what is the subject matter of the copyright, what is protected here is we have different headings like that. So let me tell you, literary works are there. Okay, then we have artistic works, dramatic works are there, musical works are there, and computer program is also protected. Their corresponding sections, definition sections are given above. And what are the copyrights protected with respect to them is given in the below column. Okay. Before that, let me tell you, when you tell literary works, what do you imagine? What will come to your mind? Don't worry, we have made a separate chart for that. When you talk about literary works, it includes something like table, even a tables, computer database, instructions given in words, codes, schemes, etc. Everything. Okay. And any books, everything. And next coming to dramatic works means anything which is like a recitation. It can be a choreography. It can be some arrangement. It can be an acting. Everything comes under dramatic works. And musical works, you all know the music as well as the graphical notations. You know, the music book will have something like, it'll be like a 4 lines note because I never knew how to write down music or something. They will have these musical notes, right? So those are also protected under musical works. And then when we talk about artistic works, yeah, artists, painters, paintings, sculptures, drawings, which include even a small diagram, map, chart, a small plan, everything. And engravings, photography, and also work of architecture, and also work of artistic craftsmanship, anything for that matter. I think in China, making a wooden box with shells are quite famous, it seems. In wooden box, they will crave in the wooden box and carve in the wooden box, and in that carving they will fill it with pearls, it seems, pearls, gold foils and all those things. It's very costly. And in India also we have this Tanjavur painting in Tamil Nadu, that is done in gold. Okay, so those things, craftsmanship, everything comes under artistic works. Next, coming to cinematography films, we all know we have this visual recordings in any medium, be anything which is moving, and sound accompanying the recording, video films, everything is included. And sound recording is something like recordings which can be reproduced. That's all. See, just have an idea what each thing means. We are going to see in depth in each of the slide, but just I'm giving an idea what is protected. Okay, so now these are the works that are protected. You have to know the definition, the perfect section, and also what are the rights protected. In case of literary works, the protection is given under 14 class A. It says that nobody can publish or reproduce it. to translate it, to adapt it, to convert it into music. So I write some literature, some poem, and somebody is going to make it as a song. They cannot do it without my permission because I own the copyrights. Okay, so that is the thing. In case of artistic work, they cannot perform it in the public, they cannot broadcast it, they cannot adapt it in some other work, they cannot make a film out of it or create any soundtrack or recording of it. So in case I am a very good dancer, I'm doing it in public, nobody can copy my form and do it again. Okay. But if it is available in the public domain, they can do it. Anybody can do it. Okay. But if I am doing it, somebody record it and put it in some other place, which I'm not aware of, then it is infringement of copyright. Now, coming to dramatic works, you cannot reproduce it, publish it, or make a cine film of it or adopt it given under 14A itself. Next, coming to musical works, cannot broadcast it, perform it publicly, make sound recordings, or copy it. And finally, coming to computer programs, you cannot sell it or commercially rent it or to reproduce or give it for purchase for someone. It is given under 14B. So you have to know what are the works that are protected, under what sections they are defined, that is given above. What is copyright associated with them? Copyright does not say, as the name goes, it is not just like copying by the book. Not like. It is like reproducing, publishing somewhere, adapting it, even translating, dubbing a film to some other language. Those are all copyrights. So copyrights are basically a bundle of rights. So it is not a single right. Okay, that you must understand. Now let's move ahead. Don't take notes because I will be sending the PDFs to you. So you can take notes after the class. You spend just half an hour, your notes will be ready. And tomorrow take the test, your exam ready. That's it. Okay. Now coming to a case law, which is very, very, very important. It gives answer to an important question. Whether registration of copyright is mandatory. Say for example, I write a very good poem today and somebody copies it. I go to court and says that I am trying to get an injunction that stop the other person from publishing his poetry because it is my poetry. I am the author. And the court says you are not registered, your copyright is not registered, go away, we cannot protect it. Can the court say like that? No, it cannot say. Registration of copyright is not mandatory. I being the author, the creation per se will give me the right that is called as copyright. Okay, registration is not important. So even without registering a copyright, I can get an injunction against any person who is using it. So the first owner will have the copyright even without prior registration. That is a very important point. Next, we have another type of rights called as performer's right. So who is a performer is defined under section 2QQ, 2 clause QQ. It includes an acrobat. Acrobat is like everyone would have seen an acrobat if you have gone to a circus. Okay. The person who is doing a very hard bodily movement is called as an acrobat. So like a gymnast or something like that. Okay. So acrobat, be it a musician, singer, actor. You see, anybody would have written the lyrics of the song, but he's acting. He will get the performer's right. He's performing it. Okay. And snake charmer, even a person delivering a lecture. So it includes myself. I am also a performer here. So I will also have the right. So who is a performer is defined under 2 clause QQ. And what is performance is defined under 2 clause Q. Performance means any visual or acoustic presentation. So what do you mean by that? Visual is something that you can see through your eyes. That's it. And acoustic includes not only words, it includes sounds also. So if I am doing any mime, yet I am a performer because visually you are seeing it. And if I'm singing some songs or making any weird noise and it is quite famous, that is also an acoustic performance, right? So by sounds or visually, they are doing something that is called as a performance. And the person who is doing that, like acrobat, musician, singer, actor, juggler, and even delivering lecture is called as a performer. Okay. Now, what rights I have? that is given under Section 38. Copyright Act provides that the performer will have the exclusive right to do the following. So if I'm taking this lecture, I will have all these rights. First, I can record it, can make sound recording or visual recording. Okay, and can reproduce the sounds recording or visual recording. So not only recording it, I can reproduce that. That's how I give the recorded versions of the lectures. You listen to the live lectures and you will get the recorded lectures in your application, right? So that's also I have the right to give. Now, next, to broadcast the performance. Yes, if I feel okay, I can give it in YouTube. I can broadcast that in YouTube as well. Okay, since I'm a performer. Next, to communicate the performance to the public. So what I can do, I can run an ad stating that, see, I have taken this copyright ad. So if anybody wants, you can visit the YouTube. So I can inform the public regarding the performance. So these are the bundle of rights which a performer owns, and it is called as a performer's right. This performer's right has been a previous year question, so better you know this. That's very important. So every slide here is culled out from the previous year question. So once you complete this class, you will able to answer all the previous year questions. Now coming to the point, how long will I own all these rights? Whether it is eternal till I die? No. The performer will have these rights for 25 years. So from this date, the lecture cannot be reproduced, cannot be done. I'll have the right to reproduce everything for 25 years. After 25 years, yes, Anush, Pooja, Soumya can take this lecture and put it in the public forum. Okay, just for comparing, that's it. Okay, so you have to know what is performance rights. Now coming to the next type of people who are called as broadcasting organizations. Okay, we have different TVs, right? Like it's not, I'm talking about the television. I'm not talking about the television. I'm talking about the different channels. You will have Star Vijay and Star channels, HBO, and also some action thriller channels. I don't remember much channels because we switched to Netflix, Hotstar and all those stuff. But earlier we used to watch HBO, and also Sun TV is quite popular in Tamil Nadu. And then we have all regional TVs and all, right? And Vijay TV and all those stuff. So these are all broadcasting organizations that exist in television as well as radio. And they have been given certain rights. What are the rights? They are called as rights of broadcasting organizations, and their rights are specified under Section 37 of your Copyright Act. So one more thing I would like to say, when we are reading in college, we used to read from Section 1 to end, if at all we are reading. Okay, but it will give us satisfaction. But in UPSC, it will not fetch much marks. It is always concept oriented. These concepts are repeatedly asked. So whatever concept that is related to this particular section and all the features of that concept is important to be retained. Okay, that's why we are going concept wise. Now coming to the point, Section 37 gives the rights of broadcasting agencies. What are the rights they have? Let me tell you. They have the broadcasting reproduction rights. That is, they can again and again reproduce the same thing. Again and again post the same thing. That is like what happens practically, I tell you. When we were studying 5th standard, 6th standard, one particular Sundays and all quite famous, we will have a new movie which has been like telecasted in the TV. It is not brand new as we see nowadays in Netflix. It will be some 5 years old. But that will be the first time it is put. When it will be telecasted is during Diwali or some like Christmas or something like that only. Once they put it for Diwali, the whole year they will repeat it for at least 10 to 15 times. Okay, they will again and again and again put the same thing. That's what is reproduction right. Now only I knew that they are using this right so powerfully. So the agencies who are broadcasting certain artistic work or any cinema work are called as broadcasting organization. They exist in television and radio, and they have certain rights that is called as rights of broadcasting organization under Section 37 of your Copyright Act. What is the special right? The right to reproduce, reproduction right. And this right is available to them for 25 years. So you see that film, if at all Netflix and all did not come, I would be seeing the same film for 25 years. They will get the paisa vasool there. They will put it again and again and again. That's what is called as a reproduction rights of the broadcasting agencies. So please do remember that. Now, coming to another point, which is a very important point, very deep one, that is caught by UPSC and made as a question in 2030. Let me tell you, the copyright exists in the expression, but not in the idea. Once again, let me read you. The copyright exists in the expression and not in the idea. So, if I am planning to take a class, I am planning like I have to say all these things, I have to give an introduction, I have to color out the section, I'm planning everything inside, right? Whether that is protected or the lecture I am delivering is protected. Whatever I am thinking is the idea. That thinking is not protected. Whatever I think can create something that is patented, that is different. Okay. But my expression, I thought of all these things. Now I am delivering my idea. So the delivering I do in my expression by speaking, by telling you everything, right? So that expression is protected in copyrights. So let me tell you, unlike patents, in patents, the idea is protected, the novelty is protected. But in copyright, the copyright protects the expression and not the idea. However, whatever novel idea I may have in mind, copyright is not concerned about that. I come onto the stage, I dance, I sing, or I take a lecture, or I do some performance. That performance is protected, that expression is protected. So unlike the patents, copyright protects the expression and not the idea. That is asked in 2013. So this was always taken care of by two important case laws. So in this case law, it was retreated that copyright do not protect idea, but particular expression of an idea was given here. As well as in this case law, it elaborated the word what is originality, it means and everything. So do read this after the class. Okay. We shall not spoon feed much things. So certain areas we need you to work upon, read and come back in the answer writing practice. Okay. That's how you learn the skill of answer writing. That's one thing. Now we will go to the definition of copyright because all along we saw a lot of things, but we did not see the definition of copyright. What is copyright? It is a right given to creators, the authors. Creators are called as authors. Okay, creators of literary, dramatic, musical, artistic works and producers of cinematography films. Okay, note this word. I'll be asking a question in that. It is producers of a cinematography films and sound recordings. So it is some right which is given to creator of all these works. And it is a bundle of rights. So you have to write the next point is it's a bundle of rights. What and all the bundle contains? Because we get some combo, North Indian thali we get from hotel or something. What we'll get? We'll do chapatis, and then you have 3 to 4 sabjis, and then you have a raita and some noodles or some what else I think some rice will be there, right? And you have a lassi. So these are all combos like that. You have a bundle of rights. What rights? Like rights to reproduction and right to communication to the public. So you can reproduce the same work and also communicate to the public about the work and you adapt the work. You change the mime to a song. See, mime to a song is very difficult. So mime to a dance or something. Then the dance to a film and the film and class like from novel to a film, something like that. You adapt it. And translation of the work is nothing but dubbing of films or the book written in like see if Wings of Fire is going to be translated in every Indian language, that is also okay. Now it means the sole right to produce, reproduce the work or any substantial part or material part of the work. So all these 3 points will define what is copyright as per this landmark case law. Now coming to section 14 of the Copyright Act, which actually defines So when we are talking about definition, I recommend you to always write the section and what is the definition and also a supporting landmark case law. That's how you differ from your competitor. Okay, that's why I have given you both. So copyright is an exclusive right because it is available only to you. Only you can do it. See, only you can question your husband. Okay, you have the complete right. Even if he is right, you can go and say, no, no, you're wrong. Only the wife is having that privilege. Even the mother cannot do because the mother will not torture his son, right? Her son. So only the wife is having this exclusive right. Like that, copyright is an exclusive right. Only you will be having it to do what? Or you can do it, or you can authorize someone else to do it. Certain acts. So only you can do it, or you authorize someone else to do it, like giving license or something like that. Okay, so what you are authorized to do? Literary, be it literary, dramatic, or musical work, artistic work, cinematographic films, sound recordings. Every author has a copyright in his work he creates. So who is the person having the copyright? It is the creator. The author is having the copyright and it is an exclusive right to him if he does any of these things. Okay. Now, this right of the author is inherent with him. Nobody gives it. Just because he creates it, he's having a complete right over it. Imagine our families. When we were all small, not don't leave it now also, like even after 30 years or something, your mother will come and say, see, do whatever I say. That is, I know how to take care of you. I know what is good for you. Why they are telling all these things? Just because they have created us, they have complete right on us. Like that, the author, since they have created that particular artistic work, cinematography, film, they have a complete right over it. Okay, that's called as copyright. That's an exclusive right, which they can exercise or they can assign to someone. Okay, that is like authorize others to deal with it. Okay. Now, coming to the next point, what are the characteristic of copyright? What all I told now is the characteristic. Let me repeat it for you. First, copyright is a creation of statute. So it is a statutory right. And next, it is protecting some intellectual property of yours, your creation. So it is an intellectual property right. And only you can do it. It is an exclusive right. Or you authorize someone and they can do it. So it is a monopoly right. So it is only you. You can do it. Others cannot do it. We stop the others. So it is a negative right. And finally, I told you it is a bundle of right to reproduce, right to telecast, right to commercialize, right to copy, and all these things are attached, right? So it is multiple bundle of rights. It's a multiple right. And finally, copyright protects only the form, that is the expression, and not the idea. So all these points are very, very important. If you're going to reflect this in your answer, definitely you're going to score more. Okay, then coming to the literary works. When we talk about literary works, it is something like original literary works. Okay, it is not the copied one. You copy it from somewhere and ask the copyright. That cannot be done. So original literary works such as novels, poetries, history books, or books of any subject matter. It also includes computer programs, tables, compilation, and all those things. It is necessary. See, what are these literary works? That's why that's what I'm explaining to you. So it must be some original literary work. And example is like some novel, poetry, books, history books, any books for that matter. And it also includes what? Computer programs and stuffs like compilations, data analysis, and everything will be your literary work. And what is important is it must have the necessary labor, skill, and capital, some sufficiently imparted to the product. That is, say for example, I am going to compile all the books, standard books. That's what law experts is doing. You can ask me why. See, for UPSC law optional, standard books are important. But reading all the standard books is very difficult per se because you have your GS and your prelims. So what law experts does? We all compile these standard books, take what UPSC is very keen about and make a compilation and simplify them, take it as a class, make it the notes, So yes, they are from the standard books. But what we have done the labor, skill, and capital invested to transform them exam ready, especially UPSC law optional exam ready. Okay, so we get the copyright. That's it, simple. So even though you are producing some from raw material, you put the labor, you put the skill, you put the capital, so you transform them significantly, then you will get the copyright. Okay, that's the thing. And a person is entitled to get the copyright of his work if he proves that it is not the same from the material what he borrowed, because we can create our own reading about all the law stuff and everything. But UPSC is keen only on the standard books. Even from MPJ, from the particular line, they are asking a question in UPSC examination. So taking from everywhere is not useful. Taking where the sources are, that's where UPSC is keen. So that's where we have to transform. Like that, there are different areas where raw materials are used to be transformed. Once you have transformed, to get the copyright, you have to be very particular that they are not same. You have inculcated the labor, skill, everything, that it changed drastically and it has some quality. Then you can get the copyright. That is the final point. So these are called as literary works. Now coming to the next type, which is called as a musical work, defined under section 13 clause 1. Musical works consisting music, simple as that, and it includes the graphical notation, something like you will have this, right? They will have strings, something in a like 4 lines note. Let me send the picture after the class. You will very well know pictures are not needed, yet I'll send you. So those graphical notes and notations they write is also protected, but it does not include any words. So in a song there is a music as well as lyrics. Whether lyrics are protected under the music work? No, it is protected under literary work. It is not protected under music work, musical work. Musical work protects only the music and also the notes that is written. That's it. Okay. And also the dancing, any action it is done, that is also not protected under the musical work. Musical work comes up very clean. I protect only the music and also the notes. That's all. Okay. Now coming to another point. See, it is not required to be written, any music work. Or if it is written, if it is done in notes, then that is protected. It doesn't mean that every music work, only when it is written, it will be protected. No, that music per se will be protected. Say, for example, in ads and all, we will be having some particular music, especially in Maggie. We'll have this jingle, right? Maggie, Maggie, Maggie. Yes, that is that note, Maggie, Maggie, Maggie. That music note is copyright protected, like that. Okay. Now coming to and the final point, it must be original. So this is a very important point. You shall not miss when defining any copyright, like any work that is protected by copyright, be it musical, artistic, anything. It must be original. Okay. Now coming to publication, because publication rights are very important, right? So what do you mean by publication? It is defined under section 3, making available to the public. You give to the public, you circulate to the public, you communicate to them in YouTube, Insta, and nowadays I'm telling all the social medias or in Hindu paper. That is communication. Okay, communicating to the public. Or you take the very big hall in Tamil Nadu, it's a Raja Muttaya hall. It's called as very big hall where the minister's marriage will be taking place. And if you're going there performing, that is also communication. Okay, making available to the public is called as publication. Okay. Now, coming to artistic work defined under section 2 clause C. Artistic works include painting, sculpture, drawing, engraving, and photography also, whether it has any artistic quality or not. Because which is beautiful for someone may not be beautiful for some other person. There are paintings which will be sold for lakhs and lakhs rupees, but in our eyes, we can see only a background, 2 to 3 dots here and there. But other people will think that it is very artistic. Yes, I am going to bid that for some 5 lakhs and buy it and put it in my living room. Okay. So what is artistic to you shall not be artistic to me. So it differs from eyes to eyes. That's why they say drawing, engraving, sculpture, photography, anything is artistic, but It shall not possess artistic quality, whether they possess the quality or not. If they fall under any of these headings, it is an artistic work. Okay. Now, even architecture, craftsmanship, everything comes under artistic work. So they create a comb which is engraved, carved, and it looks very pretty. Artistic work. They build a very big, very, very beautiful building, very beautiful home, be it like a Taj Mahal or something like that, and it is very unique artistic work. Okay, and it is protected. So the copyright is concerned with the visual image. Artistic work concerned with the visual imaging. No moving and all. Artistic work does not cover moving and all. It comes under cinematography. The per se, what you perceive by the eyes, the picture, the painting, the drawing, the engraving, those things. Okay. Now coming to the next step, the development from the artistic work is your cinematography film. It is of visual recording of any moving image produced by any means. So cartoon is included. Visual moving of any image. First point. Next, a sound recording along with the visual recording is also called as a cinematography film. Okay, so it can be a mere visual recording or a sound and a visual recording, anything that is called as a cinematography film, and it also will have copyrights. Of course, video films are protected and it falls under the definition of 2F. What is the 2F definition? It is cinematographic film. Okay. Now, coming to sound recordings. It is not the visual recordings. It is the hearing one, sound recordings. So, any sound recording means in any medium. Recording of the sound in any medium be that matter. It is called as a sound recording and it is protected under section 17. The original creator will have the right, which is the author will be having the right. So, all these things what we saw are the subject matters of the copyright. Now, what are the rights they will be having? The author will be having, they'll have three types of rights. One is economic right. Next is the moral rights and next are the neighboring rights. So, don't worry about the neighboring rights. Regarding an author, these two types of rights are very important for UPSC. One is economic right, economic exploitation. So I do a lecture today, I then sell it or do something, I reproduce it, and all those things are my economic right. But as an author, even if I give this lecture to Lawxpertsmv company, right? So if they are going to distort my lecture in such a way and portrayed in a bad manner, because it is for educational purpose, I spent a lot of hours learning things and I want to replicate it, spread it to others. I'm doing it. Okay. And law experts got this. They are going to morph this in some way. It is not good. They are spoiling my entire work. I write a book and yes, author as an author, I sell the copyrights to them and they own the book. Now they tear the book apart in such a way that it's not originally good. It is defaming me. Then they cannot do it. That's called as moral rights. Even though I have sold my copyrights to law experts, they cannot say that they are the owner or someone else is owner. So they are called moral rights. So let me explain to you. Don't worry. First, economic rights is right to reproduction, issuing of copies to the public, performing in the public, making translation, adaptation to the works. All these are called as economic rights. But moral rights is defined under section 57 of the Act, which is, it is the moral rights of the author just because he created the work, just because he has put the labor, sweat, everything. He has the right to paternity. What is this right to paternity? He can claim authorship. You can prevent others from claiming it. So I write a book and I say that, yes, I give it to law experts. They can use it. They have the copyright to reproduce, sell it and do everything. Still law experts must say that Malati ma'am has written this. I have the right to paternity. This is my moral right. Okay, next. And right to integrity. Prevent distortion and mutilation of my work. They take my work, they mutilate it, they take into pieces, so they degrade my work. That cannot be done. I have the right to integrity. They can use my work in a proper way. That's what is copyright. Okay. So the author will have the economic rights to reproduce everything, and still he will have an inherent moral right, which is recognized under section 57. Now, if I'm not alive, my daughter or my son can own these rights, these moral rights. That is called as the value of moral rights. Okay, so it will go to my legal heirs as well. To see, there are certain areas where the author will be like very, very particular. After giving copyrights, he will think that the product is not displayed to his satisfaction. Say, for example, I'm a very good painter. They get a they get a painting from me and they display it in the hoardings. So I gave the copyrights, I got the money, I'm happy. But when I see the hoardings, it's not to my satisfaction. The colors are not very good. Whether I can say that my moral rights are violated, no. It should be a mutilation. It should be something distorting my work, but not displaying the work to the satisfaction of the author is not violation of your moral rights. That is a very important thing that you have to note. I told you, right? Moral rights are important. UPSC has asked a question. Laws are geared to protect the right to equitable remuneration. Yes, that's why we have copyright. So you do something, you remunerate from that. You can commercially exploit that. You paid for that. You get paid for that. That's what is the first thing. Is beyond the material. Okay. In the light of the above statement, dwell on the dichotomy of economic right and moral rights under the Copyright Act. So you have to talk with the author, who is the author, what rights are protected, and what are the two important rights he is having, the economic right, what are the economic right, and what is a moral right? Why do we have moral right? Because it is inherent in him. He has put the blood, sweat, and everything. He has created it. So he is the author. That must be recognized. And it shall not be mutilated. Okay, so all these things. Now coming to another question, I have brought out the exact answer for you. So you will understand how to give an introduction and all those stuff. Okay, this is there in your previous year question. So solved. You can look at that as well. So coming to the question, laws are geared to protect the right to equitable remuneration. Yeah, moral rights. So first, what I have done, we have given what actually is a copyright, and then talking about section 57, which is a moral right, and you give what are the two types of the moral right, and then you say that it is recognized even under the international convention, which is the Berne Convention, which is talking about moral rights. So you get more marks, and then you give two important case laws, and this case law is where they got the statement. Okay, every statement-based question in UPSC is from some case law, from some author. It is not important that you have to recognize it. But if you understand the demand of that statement, that is enough. So you explain the statement here. And finally, you talk about whether the moral rights can be waived. Yes, of course, they can be waived. You give examples of economic rights, what are important and all those stuff. Like that, you write your answer. Now, coming to next question, why I'm going with question headings is that, see, if you're going to cover every section of copyright, that's not useful. So what we are doing, previous year question and concentrating in that area. Okay. So in the present time, there is a conflict between the right to access of knowledge and copyright law. Explain the statement in light of doctrine of fair dealing under the copyright law. See, yes, I want to learn something. Somebody has written a very good book. My access to knowledge is stopped. Now what happened? He has a copyright. That's what is stopping my access to knowledge. Okay. So there must be a balance which must be sought. I want knowledge and he want to protect his commercial right. Now my knowledge right and his protection of copyright is clashing together, is fighting. So how do we solve that? That's why we got the concept of fair dealing. That is what asked in this particular question. So you will start with what actually is a copyright and where it is protected. And then you straight away go to fair dealing, which is dealt under section 52 capital A. Fair dealing of literary and all those things means private use. See, today, yeah, I'm taking the lecture from where I get the material, from different standard books, from the different judgments, right? So I come to know all these judgments from different various articles. So I'm using it to gain knowledge. Okay, so that is allowed. And if I'm going to research and put a thesis, yes, I can read others' books and reproduce it in my own way, in the research way. Yes, that is allowed. And if I'm going to criticize MP Jain's book, it's a wonderful book. I'm just telling you. If we are going to criticize something, review something, that is all allowed under Section 52. That's what is called as fair dealing. So, what is fair dealing? You have to explain it well. And then, what is the purpose of this doctrine? See, what is fair dealing differs from case to case. That also you must say. Fair dealing depends upon the facts and circumstances of the case. And how do you determine whether the particular use is fair dealing or not? Like you have to use your basic common sense. That's what given in the case law itself. So, what you will analyze, what all you will see to understand whether the person have used the copyrighted material for fair dealing or not. First, you have to see what is the purpose of the use and what is the nature of the work and what is the amount of hard work they are putting or amount of work they have used. See, entirely copying one thing is different, but taking what is relevant, taking few things and then making your new thing is different. That is fair dealing. Okay. The effect and use of work on the originality. So I'm not copying much. I'm taking only 2 to 3 lines from a big book. Then it is not going to affect the original one, right? See, there is one book which is of 100 pages. I'm taking only 2 pages and making a separate book. Okay. Now, whether the original owner can complain on me, no, he cannot because I have taken very little material from that. And the new book is not going to stop the sales of the old book because it is completely new. Only two papers are going to be taken from the other book. Okay. So that and all you have to see the purpose of the use, the nature of the work, the amount of work used, and the effect on the original version. Okay. All these things you have to see to decide whether there is fair dealing or not. We have a case law, but I would recommend you to write the latest case law. As for time being, this is the latest case law, but just before your examination, we will have a class on current affairs. That case law you have to quote to get good marks under the CLD. So this case law, Richard Cadre versus Meta Platform Inc., is a 2025 case law. Very important case law. What happened? You all know Meta is developing its AI model. It wanted to teach the AI model different forms of languages and writing and all those sort of things. So what it did, it took books from others, all the books, and it started to train its AI models with these books. And 13 authors of these books, they own each book, right? So 13 authors joined together and they have put a case against Meta in US stating that Meta is training their AI model with our books. And it is taken from Shadow Library. That is pirated version of my books. And they are training the Meta AI model, which is copyright violation. The court told training AI model is like, it is transformative. They are not taking your entire book. They are taking selective areas and they are transforming, using their blood, sweat, everything and transforming it. So it is the fair dealing. So this case law is a landmark case law for your fair dealing. Okay. So ultimately Meta won. And the author, like, it is not a copyright violation because it was a fair dealing. That was stated. Okay. Now we will scroll back. Yes. Now we were talking about copyrights. What is the term of this copyright? How long these rights are protected? That is given here. A lifetime of the author plus 60 years, it seems. The person who creates his lifetime plus 60 years. In case I'm writing a book now, and see, really, I don't want to die. But for example, I die at 80 years. After 80 years plus 60 years, it will be protected. That's how it is. If it is co-authored, see, co-authoring is very important. It will take the 60 years will be calculated from the death of the last author. So have as much as authors you can. Include one 15-year-old or 18-year-old or 19-year-old. So your work is protected for a long time. Okay, that's it. Now coming to posthumous work after that death it is seen or any Anonymous work. Most people will have the pen name. They will not say their original name in drawings and all those things. Okay. So anonymous work and anonymous work, name is not given. Pseudonymous work means name is given, it is a pen name. Okay. Next, photograph, cinematograph, film, sound recordings, and all those things. If it is posthumous and all those things, how will you calculate the lifetime? The author itself is not known. How you will know the lifetime of the author? When he is dead, then calculate the 60 years. So you let go the lifetime and calculate only for the 60 years from when it is known to the world. Supposedly the painting is known today. 60 years, you cannot copy it. After 60 years, no copyright. Okay, that's it. Okay. Now coming to broadcasting right, it is for 25 years. Performance right, it is for 25 years. So whatever I told you is given here along with the section. So quote the section and talk about what type of work and then how many years it is protected. So posthumous work, everything that I have told is given along with the section. Do take notes after the class. Now, it is all protected. See, I am a author. I am a painter. I do very big drawings and very good thing. Everybody adorn my drawing. But I don't know how to make money of it. What will I do? See, I have very good sense of doing artistic work and all those things, but I don't know business. I cannot make money out of it. So what I will do, I will license my work to others. So the owner of my copy of the copyright can grant interest to a third party, a license to a third party. See, the ownership is with me, but the license to do certain things, authorization of certain act to be done by the others. Okay, that can be done. So I have all these, I own all these paintings, but I license the other person to sell all the paintings. Okay, so that can be done. The person to whom I gave the license is called as the licensee. Okay, now there are areas where compulsory licensing can be given under certain terms, but compulsory licensing under Copyright Act is not important. Compulsory licensing under which act is important? Patent Act is very, very important. Okay, read that compulsory licensing. This is just if you understand, that's enough. Okay, next we have assignment. It is not licensing. In licensing, the author will have the ownership. Only certain authorization is given. That is licensing. But assignment means I give everything to you. Ownership also you own. So if the author itself redo my work, copy the work, even though I am the author, I assign my work to you, my copyright to you, everything to you. Now, even if I reproduce, it amounts to infringement. So ownership itself is given. That's what is called as assignment. So you give away the copyright to the other person, you do away, and no longer you are the author. So after assigning, if you are using it, if you're doing it, then the author is infringing that work. Okay, that is the power of assignment. It is dealt under section 18. So how do you assign it? What are the modes of assignment is very, very important. So you do it by writing and signing, just like a property that we give, right? Transfer of property. Like that you do it. And you mention what are the rights assigned? What is the duration of assignment? Specifically like 5 years, 10 years, 7 years. And the territorial extent. So I assign this rights, copyrights to you in US only, in China only, in India only. Like that you have to do. And what is the royalty amount that you get back? And all those things you have to mention. Now we get another topic called as transmission of your copyright, which means after your death, who own your property? It is your legal heirs. So if they are owning your like tangible properties like a motorcycle, car, Lamborghini, and your beach house and all those things, it is transfer of property. But it is not dealt under transfer of property because it will be dealt under the Indian Succession Acts. Okay. But in transmission of copyright, same way, your intellectual property, right? Copyright, that goes to your heirs, your public, that is like author is dead before your publication. You make a work, but you are dead before your publication, then all the copyright is owned by your heir. The heir will be having the manuscript actually, original document where the work is written, Say, for example, I'm writing a very big novel and it is so big that I wrote it for 80 years till I'm 80 and I am dead before publishing it. So my daughter publish it. Yes, she can do it. She will be having the access to manuscript. So my right transmits to her. So this is called as transmission. And this transmission will can be done by a will or by even without the will or something, anything. And the person will have the manuscript and also will have all the copyrights. That's very, very, very important. Okay. Now, coming to relinquishment of the copyright, yes, the author can give away, relinquish all the copyright, but before that, they have to give a notice to the copyright registry, and the registry, after seeing all the genuinity, will publish it in the official gazette. Okay, I can relinquish my copyright as well. So even my moral rights, I can relinquish if I want. Okay, coming to next point, which is infringement of copyrights is very, 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 very important. It's very important. I told you, right? Copyright is a bundle of rights. And see, if you are going to give it to the licensee can use it. If it is assigned to someone, the assignee can use it. But you don't do anything. The person who's not at all related, not a licensee, not a assignee, but if they are using it, then it will be a copyright violation. Okay, that copyright violation is called as infringement of copyright. But what are the exceptions to infringement of copyright? Fair dealing, reproduction for the judicial proceedings. Say some judicial proceeding is involved on defamation. Someone says that your book is defamatory and he is bringing the book and he is giving all the copies to the judge and the opposite party and all. And you say, my copyright is violated. He is publishing to everyone. I have the copyrights of my book. No, you cannot say it is a judicial proceeding. That is an exception. Next, reading or recitation in public. That is like, it is covered in the, see, something which is already available in the public domain. Whether you can infringe it, that cannot be done. Next, publication in collections of educational institution. Yes, for the educational purpose, it is allowed. And reproduction by teachers or pupils. I am teaching you and I say that this is from this particular book, allowed. Okay, so all these things are exception to infringement of copyright that you have to note. And finally, I have brought up two questions which is talking about infringement of copyright. I told you, right? Infringement is an important area. So you have to know all this. Go read these two sections. Tell what is copyright, then what is infringement, and what are the exceptions to the infringement. What are the rationale for the exceptions that you give? That is totally enough, which can cover up to 2 to 3 sides actually. Okay. Now, certain things I told are not infringement of copyright. We see already fair dealing, adaptation in computer for specific purposes, reproducing current events. See, Hindu is reporting a lot of current events. And whether Hindu can say, right, I have the copyright, I am the newspaper, I reported it first, and others cannot report it. No, current affairs, current events reporting cannot be copyrighted. Okay. Next, reproduction in judicial proceedings, legislative purpose, certified copies, it is protected. And reading, reciting, I told, for pupils, teachers, and all things are protected. And newspaper reproduction is also protected. So these are the exceptions. If you write some 6 to 7 exceptions, that is totally enough. Okay. So now coming to the remedies. Yes, my copyright is violated. What remedy I will have? I will have civil remedies like injunction. I will stop the other person from continuously reproducing it. Say, for example, I have taken a film and I'm the producer of the film. So I own the copyright and someone else is making like duplicate copy of my film and putting it in some forum or something. I can get an injunction stopping him from doing it. Okay, injunctions. Next, damages in accounts. See, so much CDs you have given. Okay, all in wrong platforms you have sold it. Okay, now so much of loss I have incurred. You give the damages. You give the accounts how much you have sold. So all these things. Delivery of infringing copies. You have it in the pen drive. You deliver the pen drive. You have all the CDs copied. Give the CDs back. And next, damages for conservation. So I have conserved it for so long. You have done it like damaged it. So what all odds I failed? Even for my emotional damage, I can get compensation. Next, what are criminal remedies I have? I can have the accused imprisoned. I can ask them to pay the fine and seizure of all the infringing copies and deliver it to the owner. And then talking about administrative remedies, I will be moving the matter to the registrar of the copyright to ban an import of such copies to India, because most of the CDs at that time in 19 see in 90s 80s, I don't think like that time when we were studying 10th or something, last 15 years, 20 years, 25 years back, some say like 20 years back, okay, like that. CDs were very, very common. We used to play games in CDs and we used to watch movies in CDs. Any new movie, they will have this theft CD. Okay. And this theft CD will not be done in India. They will take the original copy somewhere abroad and they will do the CDs and come back. So this series, we can stop it from entering in India. Okay, that is an administrative remedy that we can approach the registrar of copyrights. So that is one thing. And delivering of infringing copies confiscated to the owner is also an administrative remedy. So when we talk about infringement, try to give few points on remedies as well. So infringement, what is infringement and why it is called as an infringement? What is the rationale? And then you say what all is not infringement, exceptions. You say and explain with rationale and finally talk about remedies. Your answer will get a complete form. Okay. Now, see, we have two important case laws. In this case law, it has been stated that particularly for remedies, we can quote this. There are cricket matches, which cricket matches are quite famous across all over the world. Okay. So there were rogue channels which were telecasting cricket matches without license. So the case was filed to stop. It was to get injunction from like publishing the cricket matches by the rogue channels. So others who are trying to telecast the cricket matches, I got an injunction against them. Okay, this was a classic case for injunction. It prevented infringement of copyrights because only these people, cricket matches, yes, I can take the video and I can telecast. No others can do it. Like that, they got the injunction. And next, we talk about Section 63 of the Copyright Act, which makes the copyright offense, which is infringement of a copyright, a cognizable offense and a non-bailable one. So even without the order of the court, they can arrest you. It without arrest warrant, they can arrest you, they can investigate you. And when you go to court for bail, as a matter of right, you cannot ask the bail because it is non-bailable offense. Okay, that was declared under Section 63 and also was reinstated in this particular case law. Okay, so these things are quite important, but this case law is not important because it is a 2022 case law. It was about dubbing of a movie. Today, as of now, this case law, Richard versus Cardley, which is about meta platform AI training, is very, very important. But when you go to examination, just before 2 months, we will have a separate class for current affairs. If you're able to code that current affairs, that will be totally sufficient to get good marks. Okay. So we have completed today's class. I thought it will take much time. Just now I'm checking the time. It is 6 o'clock. So if you have any doubts, it's my pleasure to solve it. Any doubts? No
Ma'am,
doubts as usual. Tell me.
ma'am, can we just get an example like how to start the introduction and how to
Yeah,
conclude
you
it?
can, you can. Like, yes. Any question you want to give me and you want to know the introduction, or like let me pose a
Yeah,
question for you
ma'am,
and you try?
just for 2 to 3 topics like that, so that we
I
can
don't
get a
understand.
pattern. Just to get the
There is no
pattern,
pattern
ma'am.
for introduction, Nandita. It is every person specific. So what you do is you take some 3 to 4 previous year question. Okay, you try to give an introduction and send me. Let me tell you how you are handling it.
Okay,
Okay,
ma'am.
because
Okay.
it is person specific. It is not that generally everybody will have this pattern and you go with the pattern. Then how do you score much mark in UPSC?
No,
Okay.
ma'am. The thing is that for GS and all, we used to start the introduction either by giving a data or a or something catchy. But in law,
Yeah.
I couldn't understand like what kind of introduction should we give.
Mostly you go with what actually it is. Go with the demand of the question if it is for 10 marks, because you will be
Okay.
having 1.5 side to 2 sides only. Okay. So
Okay,
you
ma'am.
straight away introduce the topic there. Okay. What is the main section it is and all. Okay. That is introduction.
Okay,
Then
ma'am.
body you will solve. You explain everything in detail. That is body. And finally conclusion, you give way forward, how better it can be. Okay. That will be your way
Okay.
forward. Okay, that you
Okay,
can do.
ma'am.
Or else you can take any quotings from the judgments, quotings from the authors. That was done by few toppers. You'll get good marks. That can you have
Okay.
for introduction. Okay. And when you come to torts, you can have the maxims as introduction.
Okay, okay,
Okay.
ma'am.
And if it is a doctrine, say for example, it is a doctrine of repugnancy, something like that. Why do we have this doctrine? So that will be your
Okay.
introduction, something like that. Okay.
Okay,
So
ma'am.
you just try 2, 4 questions and send me and let me improve that
Okay,
for
ma'am.
you.
Okay, ma'am. So, ma'am.
Okay. Done.
Thank you, ma'am.
So, thank you, ma'am.